Genova Burns has been serving our corporate clients' needs for 35 years. John Quincy Adams said it best when he said, "He who tells the best story wins." And this is our story. My name is Edward Bonnet. I'm an attorney with the labor law practice at Genova Burns and a law professor at Villanova University Law School. I'd like to talk to you today about what you can expect in labor law from a new Trump administration and how that might be different from what we've seen the past 4 years in a Biden administration. So first off, most of what I'm going to be talking about involves the National Labor Relations Board, or I'll use the term the board in describing the National Labor Relations Board. Okay, so first of all, labor law is one of those areas that is very different, viewed very differently between the parties. The Democrats typically will be more geared toward labor-friendly decisions, and the Republicans will be more geared towards business-friendly decisions. And I think you'll see that in general. But let me talk to you about a few topics that you're going to see some changes. Number one is joint employer status. So joint employer status means that two companies, both a company that has daily control over terms and conditions of employment and another company that has some, I would say, authority over terms and conditions of employment, can be considered joint employers for terms of liability for unfair labor practices and to sort of pin the two companies together for responsibility in bargaining with a union. Now, under the Biden board, the rule that the Biden board was putting out there was that two employers are joint employers even if one of them only has authority over terms and conditions of employment and doesn't even exercise that authority. The Trump board is likely, given what we've seen in the past, to say that no, an employer is not a joint employer unless they both have authority over terms and conditions and exercise that authority on a regular basis. So you're more likely to see situations where two companies are not considered joint employers in the Trump administration. In the other area is independent contractor. So independent contractor is a big issue, especially with the economy and a lot of people kind of working gig work or piecemeal work or freelance. So under the Biden board, there was a case called Atlanta Opera Company. It involved wig makers, and the board said, the National Labor Relations Board, in a decision, said that the putative independent contractors were actually employees under the act, which meant that they had the right to unionize. They had a whole panoply of rights under the National Labor Relations Act. They said that you look at a whole bunch of factors when considering employee versus independent contractor. The Trump board, and there was cases under the first Trump administration, would say that if a worker has entrepreneurial opportunity of a certain extent, then that person, despite all the other factors, is typically considered an independent contractor. So that would make more workers independent contractors than employees. So you're likely to see that direction in the Trump board. One huge area is in organizing, union organizing. So under the Biden board, the board issued a decision called CEMEX, C-E-M-E-X, whereby it made it easier for unions to organize a group of employees. And what they did was they said if a union collects cards, signatures of a majority of employees, and they submit those to a company, the company must recognize and bargain with the union, and the union doesn't have to seek an election. Now, the company under that decision would have to go seek its own election. But if the company commits even an independent, single, unfair labor practice in that time span, the board would say you're ordered to bargain with the union without an election. That dramatically changed the field and kind of reversed a situation that's been in place since the beginning of the National Labor Relations Act in 1935. The Trump board will most assuredly try to send a case up to the NLRB, to the board, to reverse the CEMEX decision and put it back to unions have to seek an election if they want to try to unionize. Handbook rules. This is another area where the Biden board sort of tightened up what an employer can put in its handbook by looking at the handbook rules from the perspective of sort of a vulnerable employee, and how would that employee look at it if that employee chose to try to unionize. The Trump board will look at these rules and say, is there a legitimate reason for the rule? Is it to protect civility in the workplace? Maybe ensure that the workplace is safe? That's how the Trump board's going to look at them, as opposed to how will it affect union organizing. Okay, so you'll likely see more rules that will be lawful that employers have, as opposed to more rules being thrown out because they might impair people's Section 7 rights under the National Labor Relations Act. That means the rights to unionize. And then a big area that has been percolating in recent years is college athletes, right? So you'll ask, what are college athletes employees? This has been the big question in the past few years. This current National Labor Relations Board would say yes, college athletes in certain situations, like big-time college football, big-time college basketball, those are employees of the universities, and therefore they have the right to unionize. They have the right to be protected under the National Labor Relations Act, and there's cases percolating through the legal system that are going to get there, that this current Biden board is hoping will kind of cement this employee status for big-time college athletes. The Trump board, and maybe even a Republican Congress, are likely going to push back against that and say these are athletes, these are college athletes that are not employees because of recent NIL decisions, name, image, likeness. They have the right to make money, so that's not such a big issue anymore. And let's not take the big step and call them employees, because that comes with a whole bunch of ramifications. So I think you're likely going to see that. And finally, in the area of remedies, so the current National Labor Relations Board has been pushing an expansive realm of remedies in its cases. So, for example, what they've been seeking in terms of, let's say, if an employee is discharged for union activity, typically the board would order equitable remedies, make whole remedies. But what you've been seeing under the Biden board is pushing that envelope into any consequential and foreseeable remedy that might be there. Okay, so that has actually put the board in the crosshairs of constitutional challenges, where companies are saying those kinds of remedies are not in the jurisdiction of a federal agency. Those are in the jurisdiction of the courts only. And so I think what you'll see in the Trump board is they'll kind of tighten up the remedies, make sure that they are equitable remedies that are in the realm of a federal agency and not in the courts area. So there you have it. My name is Edward Bonnet. I'm thankful that you took the time to listen to this podcast, and we are here at Genova Burns to service your needs.